Hi guys, my name is Kabir and you are watching Clat. So in today's lecture, we will cover the Digital Personal Data Protection Act. Now what this act is about. Before coming to the act, a bit about myself. So I have completed my LLB from NLU Ranchi, then I have done my LLM from Rajiv Gandhi College of Law, and then PG Diploma from NLU Hyderabad. I just want you guys to be in different colleges, particularly in West Bangalore, Nalsar, and New Delhi, and the top 5 law colleges. And for that, we would be studying and covering the Digital Personal Data Protection Act, which is very important for your Clat, ALET as well as OLET examinations. So particularly what this act is about. This act is of 2023. Okay, and we need to study why is it necessary, particularly from the critical reasoning perspective, particularly from the editorial perspective. Then we have certain logical reasoning statements. In fact, we have current legal knowledge with respect to this, and we have questions in ALET coming up. Okay, so need to understand what is the need for the DPDP Act. Let's go with this. In the DPDP Act particularly, there are certain things that you need to take care of. First, this act would confer rights and duties. That confer means to give. We will give to ourselves, that is the Legislative Assembly, Lok Sabha, Rajya Sabha plus President have passed this Digital Personal Data Protection Act to give to ourselves rights as well as duties. For example, there are data fiduciaries, data bodies who have a certain duty. You as an individual have certain rights. So there's an important balance we are striking up to protect the users and promote the innovation in the digital business. Moving on, we have recognized the right to privacy. That is the reason you are having this right in the DPDP Act. Right to privacy. When I was in my law school way back in 2017, I used to read the 600 pages judgment where it was written that case Puttaswamy versus Union of India would establish in the year 2017 that under the Article 21 there would be right to privacy under this particular right. So this particular right gives you a space in the digital space as well. So you will have a private life, like an offline life, and then you will have an online life, the digital life. Okay. This right have been established by the year 2017. This case is pretty important for you guys. Okay. Now moving on. From the economics perspective, from the growth perspective, digital transactions, for example, UPI, BhimPay, Razorpay, BharatPay, Paytm, these social interactions, these applications interact with, for example, Instagram, Snapchat. Then we have other payment gateways. So if you have social interactions, if you have financial transactions, both of them are covered in this. And there is a common aspect that is involved in both these type of platforms, that is your personal data. So what we need to do is we need to protect this personal data in the digital hemisphere. Okay, moving on. Protection and security. This very aspect, this act of 2023 enforced to protect the rights of users, protects and secures your data as well as the process of the data for the lawful purpose. If your data is used for an unlawful purpose, your criteria are not met for this very act. The main objective of this act is to confer rights and duties to protect your personal data for the growth of economy, because it is enshrined in Article 21, and thus if you are not doing it, then there would be imposition of penalties. So for example, if you are not doing an act, if you're not doing an act which is lawful, if you're doing an unlawful act, illegal act, then there are penalties, then there are punishments. So if you have a certain duty and you're not enforcing that duty, you're not obliging by that duty, then there are penalties being imposed for unlawful processing of personal data. Now we'll see what is actually personal data. Okay, but before moving on, we'll see a brief timeline about it. Like how does it go about? So in 2011 till 2024, we have basically Ministry of Personnel and Public Grievances and pensions starts. So basically in 2011 to 2014, we have this very ministry which have drafted the privacy bill versions dealing with data protection and surveillance reform. But the work halted. There was no materialization of the act in itself, but there were certain drafts which were being prepared. Then there are more certain intricacies involved in different year, but we'll not deal with it. We'll see the most important parts only. So in the year August 2017, as I told, Supreme Court affirmed right to privacy as a fundamental right under Article 21 of the Constitution, with the judgment K.S. Pottuswamy versus Union of India. And this K.S. Pottuswamy is a retired Chief Justice, Okay, so he have asserted that we do not have a right to privacy, particularly in Article 21, which is essential for our life and personal liberty. Okay, then moving on, in July 2018, the Sri Krishna Committee releases a 176-page report which proposes the Personal Data Protection Bill. This is a crucial aspect for your ALIT's understanding. Okay, so this report, Sri Krishna Committee report, have released this 176-page report. Very important. Moving on, if we'll move forward with the timeline, then in December 2019, what do we have? We have Personal Data Protection Bill, which is sent to the Joint Parliamentary Committee. Now you will wonder, what is a Joint Parliamentary Committee? Example, JPC is LS plus RS. So when there is no consensus between these two houses like Lok Sabha and Rajya Sabha, we have these two houses, joint committee. Like you guys can discuss together and come to a conclusion, find out recommendation, have some fruitful suggestions, and then pass this bill here. If you won't pass this bill, then it would not come to the general public. And how general public would be affected? They would not be having their right to privacy particularly, or it would get delayed. So thus, to cater this whole process, a joint parliamentary committee in 2019 was established. Then moving on, in November 2022, the Ministry of Electronics and Information Technology released a draft Digital Personal Data Protection Bill. First draft came back in 2018, as we discussed. Okay, here, first draft, 2018 July. Then we have second draft, November 2022. This is the main crux. Main crux as in, this is the bill which is being given importance and recommendation because it have come after joint parliamentary committee. So it have certain recommendations, certain suggestions. Okay, then moving on. This is your CLK. That is current legal knowledge. So in this aspect, what you need to understand is MEIT, Ministry of Electronics Information Technology, have introduced a draft Digital Personal Data Protection Bill year 2023 in Lok Sabha. Like, this is the final bill that we are proposing, and we would not be taking up much recommendations on it, and thus post this scenario we would be taking public consultation on this bill. Okay, moving on. What do we have in this bill? What are the key terms in this bill that we need to understand from Clat point of view, ALIT point of view, and OLIT's point of view? What do you like? If you are aware, like, what is OLIT? OLIT is, guys, other law entrance test. Okay, so these are other exam, for example, SLAT, MHCT. We have different examinations. Okay, for example, we have NLSAT as well. So this act particularly is crucial for every other examination because it's a current legal knowledge aspect. It deals with current legal knowledge aspect. So moving on, what do we have here? We have a data fiduciary. Okay, Fiduciary implies someone who can be trusted. Okay, we have a data processor. Now, what do we have in this act? So there are certain key terms that you need to understand before this, particularly data fiduciary. So fiduciary is someone who I can trust for, like I have a sense of trust toward this person. This person is a fiduciary to me. Then we have data processor, the person who is processing the data. Data principal, who is, I think, holding the data. Consent manager, who is managing the consent. And then data protection officer. So we have these many aspects in our Personal Data Protection Act. Now let's understand something about data fiduciary. So particularly the role of data fiduciary is pretty simple. It's given in under section 2I. So in simple words, data fiduciary means any person who alone or in conjunction with other person determines the purpose and means of processing personal data. So this is the crux. Okay, this is the whole crux of the data fiduciary. That what does a data fiduciary does? He or she have a purpose, have means of processing personal data. And what does personal data implies? Personal data implies any data about an individual who is identifiable by or in relation to such data. Example, your name, your phone number, your email, your address, your gender, anything which makes you identified. By this data, I would know that this person is having this name, this phone number, this email, this address, as well as this gender. Okay, moving on. We have another aspect coming up. Since we are taking up 6 aspects only, then we have data processor. What does data processor implies? Data processor is someone, it's given in under 2K. Okay, so data processor means any person who processes personal data on behalf of data fiduciary. So we have this data fiduciary who is processing the data or who have certain means of processing a data. Then we have data processor. It's a kind of a intern kind of position, or a position which is inferior to this superior position. Okay, so this person commands or gives data to this person, and this person process the data. Okay, understood? Then moving on, we have another person in the picture. Another character in this dramatic movie is data principal. So data principal is given under 2J. You can note it down. Under the data principal, it means individual to whom personal data relates and where such individual is a child, a person. So we have two kind of individuals in the picture. We have a child. Okay. Then we have a person with disability. This child includes parents or lawful guardian. This child should have parents or / lawful guardian. Then we have person with disability with her lawful guardian. Okay. Data for these two people are being processed. So thus data principal means the individual to whom the personal data relates and where such individual. Data principal in simple words for you guys from Clat point of view or from law entrance point of view is pretty simple. That you would be a data principal if you are a child, if you are a person with disability. Simple terms. I'll give you some examples as well. Now moving on, we'll understand the 3 new key importance terms which are relating to the first, second and third term. Moving on, we have a significant data fiduciary. In the significant data fiduciary, as the name says, this data fiduciary have a significant importance. Significant importance. Let's read the definition. Any data fiduciary or class of fiduciaries as may be notified, okay, by the central government under section 10. This significant data fiduciary has additional obligations. So as of now, we understood that data fiduciary have means to process the data and have means to process the data. So this person process the data, have means to process the data. Okay. If we move with the this person is fiduciary, data fiduciary. If we have a significant data fiduciary, then there are additional obligations. Okay. What are they? To appoint data protection officers, independent data auditors, and conduct periodic data protection impact assessment. So we conclude these three things. What are the additional responsibilities this person hold? These are the additions. This person have a authority, have a power, have a control over the data fiduciaries. Okay. And what does he have? He have data protection officers. He have independent data auditors. And then he have periodic data protection impact assessment. Note this down. This makes this person significant in the data fiduciary perspective. Okay. Then moving on. What do we have here? We have consent managers. And who are consent managers? Pretty simple. A consent manager means a person registered with the board, Data Protection Board, who acts as a single point of contact, SPOC, single point of contact, to enable a data principal to give, manage, review, and withdraw her consent, his or her consent, okay, inclusive of all genders, through an accessible, transparent, and interoperable platform. Interoperable, transparent, and accessible are key terms which relates to data principal. And who are data principal? Child and person with disability, with guardians, okay, or parents. Okay. So this consent manager should be registered with board. This is what we understand. Which board? Data Protection Board. Okay. And this person act as a single SPOC. SPOC, single point of contact, to review, manage, and withdraw the consent. Who would withdraw or review or manage the consent? The child or the person with disability. So they can withdraw their consent, they can review their consent, and they want to consent to these policies of WhatsApp, they want to consent to these policies of Telegram or different platforms. Okay. The role of consent manager is facilitated and the data principal by managing their consent and is accountable to data principal. So their accountability is directly linked with data principal. Data principal. Understood? So this was the role of consent manager. Moving on, the last key term and the most crucial one. Why I am saying this is the most crucial term and the most important one and have very significant importance? Because he is the data protection officer, an authority or an individual appointed by a significant data fiduciary. Who is appointing this? Significant data fiduciary. You get the fact. We have come to this conclusion that this person is significant and have a significance importance because he has additional responsibilities or additional obligations. First, data protection officer appointment. Second, independent data auditors appointment. And third, periodic data protection impact assessment. So he has a certain sense of accountability and he is fulfilling his accountability by appointing a data protection officer. So blue is a color of reliance. So we are using blue in this because this data protection officer have a sense of reliance towards his position. This person is appointed by significant data fiduciary. Significant data fiduciary. Under the clause A of the subsection, that is not our concern. Now he shall represent the significant data fiduciary. So significant data fiduciary have a hierarchical structure. First, data processor, and then we have data protection officer. These are the two pawns a significant data fiduciary would have. Okay. Pawn number 1, pawn number 2 have different their features, different roles and responsibility, different obligations. So data protection officers represent significant data fiduciary. Thus there is a mutual relationship between these two guys, and thus in this relationship there would be a sense of accountability towards data. Okay. He shall be the point of contact for grievance redressal mechanism. So if you have a certain sense of grievance, like my data have been leaked, my pictures have been leaked, my videos have been leaked, my bank account details have been leaked, my credit card details have been leaked on different platforms like Telegram, like Instagram, like via mail. Where is the authority that is taking a look of it, getting a hand of it? This is the authority. So you would come to the data protection officer just in case if you are having any concerns. The grievance mechanism is giving under data protection officer. Okay, like moving on, what do we conclude? We have these key terms and we conclude that we have a digital personal data protection as of now, which refers to any data of an individual that is identified and processed digitally. Conclusion number 1. Conclusion number 2, we have a data fiduciary, which is any person who chooses the purpose and means of processing personal data. He is the person who is independently processing the data or in collaboration with the others. Okay. Then we have data principal, an individual whose personal data is being processed, particularly child and person with disability, with guardian or with parents. Okay, understood. Then we have Data Protection Board of India, which is a regulatory body overseeing compliances. Compliance means compliance to certain rules and regulations, adhering to certain rules and regulations, imposing penalties in case you are breaching a certain set of guidelines, you are breaching certain set of obligation, you are not fulfilling your obligation, then there are penalties which is being imposed. Okay, and these penalties are imposed on data fiduciaries or even significant data fiduciaries in certain cases, depend upon case to case basis. Because if you are not fulfilling your obligation, if you are not doing a fair data assessment audit, if you are not independently appointing the data auditors, then you would be punished or you would be penalized. Okay, and then at last they would be addressing grievances. Grievances of what nature? Data protection officers is appointed by the significant data fiduciary, and then if there are no grievance redressal mechanism, they are overseeing it. Okay, moving on, we have certain exemptions, we have certain penalties, and then we have a notice. Okay, let's start with certain exemptions. What are exemptions? Exemptions are certain exceptions. Like these are the cases in which it would not apply usually. Okay, so generally there is an application and there is a specific exception or exemption on which that general principle is not applied. Okay, this is what exemption is. Specific cases where the rights of data principal as in child and person with disability and obligations of data fiduciaries do not apply. Data fiduciary are people who have means of processing and data and have a purpose of processing data independently or with collaboration with others, subject to the government notification. So there are certain exemptions in which government might allow via notification that certain policies we can trim off. You can be waived off of certain guidelines. Then we have a notice. What does a notice entails? Notice should be concise, itemized and stated in straightforward terms according to 8th schedule of the Indian Constitution. Data principals should have option of accessing information in English or any 22 languages. So what does this notice entail? Notice implies anything which is important for data principals to be taken care of. In simple terms, who are data principals? Child, person with disability. So a child or a person with disability should be able to read this notice in how many languages? English plus 22 other official languages given under 8th schedule of the Constitution of India, which is enacted on 1950, enacted on 1949, enforced on 1950. Okay, so this is the ideal state. And why we are doing this? We are doing this to make it accessible in all sort of languages. Now we come to the penalties. Penalty is a monetary fine, that is something which is of pecuniary in nature, which relates to money, because what the central idea is, we need to impose something in terms of penalties, not punishment but monetary fines. Okay, imposed by Data Protection Board, DP board. Okay, DP board is looking into the grievance redressal mechanism and is overlooking the operations for the compliance as well. We have read in the other slide. Then we have Data Protection Board for non-compliance with the DPDP Act. If you are not complying with, we are imposing obviously penalties over you. This is what the central idea is. So what is in it? In it what? What is in the Data Protection Act 2023? Okay. Now let's start with this. The Act seeks to protect the privacy of the Indian citizen. So aren't we protecting the data of foreign citizens? The primary concern is of the Indian citizen. The Act applies to the Indian citizens only. Okay. While proposing a penalty up to 250 crores. So it's a up to wala format. What does up to implies? You will get a cashback up to 1500 rupees. If you spend around 250 rupees or you take a coupon or you do a metro recharge of 250 rupees, you will get a cashback up to 250 rupees. This is what Paytm, Google Pay, Phone Pay, Bheem app says. So would you get to 1500 rupees? Obviously not. So it's a up to format. Up to implies rupees 1 to 1500. That is, you'll either get 1500, you either get 1 or you will get anything coming between them. Clear? Then we have this 250 crore fine. This 250 crore fine is imposed on entities, different entities, for misusing or failing to protect digital data of individuals. So the fine is point number 1, 250 CR up to, obviously. Okay, this is the first point. Second, penalties can go up to 250 crore for data breach. This is for misuse. So if you misuse, 250 crore penalty. If you have a data breach, for example, you have your own application, something like on the lines of Instagram. You build a own application of you students, okay, and you're sharing your material and everything, and there is another company who is breaching your data and they hack your data servers, and there's a data breach incident happening in your server because you have a shared server. So this data breach incident would lead you to 250 crore penalty. Then we have, if you misuse the data, if there's a data breach incident happening. Okay. Then if you have failure to protect personal data or inform DPB users of the breach. So if you fail to protect and if you fail to inform whom? The users? Obviously not. Data Protection Board, so they can take some steps with respect to it to mitigate the situation. The center retains the power to restrict the transfer of personal data to any country or territory outside India. This is something very different. For example, central government have the ultimate power, not the state government. If you're based in Hyderabad, if you're based in Bangalore, if you're based in Kochi, you have different states. Okay. Would your state government have the control over your data? Obviously not. Central government would have. This is what the central idea is. Central government have the power to restrict the transfer of the data. For example, Telegram have a office in Malaysia. Instagram have a regional office in Malaysia. Snapchat have a regional office in Malaysia. PhonePe have a regional office in Malaysia. They are transferring your data to Malaysia, and Malaysia have a data warehousing system. Example. Okay. Now the servers are in Malaysia. The central government may by law, may by notification, may by rules or certain guidelines restrict the transfer, that you cannot transfer the data to any country or territory outside India, because Malaysia is a territory which is outside India. What does Indian territory entails? Indian territory entails, for example, this is India. This is India. This is your India. Okay. We have territory of India as land territory. Then we have territory of maritime belt as water territory. Then we have airspace. Then we have underground space. Then we have different islands. A group of islands, Lakshadweep, Andaman Nicobar. This is the territory of India. We can restrict the transfer of data, like the central government can restrict the transfer of data to any other country or territory outside India. Central government can restrict by notification. Okay. So central government cannot restrict the transfer of data if it is in the Indian territory. Okay. And this is what Indian territory implies. Understood? Moving on. Firms dealing with user data must protect personal data even if it is stored with a third-party data processor. This implies if there are firms, if there are businesses or organizations of any sorts dealing with user data, that is personal data, must protect personal data. That is the whole objective of the act. If it is stored with a third party, the business would say, the Snapchat would say, we do not have your data. We have given this data in the security of another company. Thus, we do not hold any liability. Data processor. In that case, Snapchat would still be liable for any data breach incident for not protecting user data if there is a case or there is a misuse of data. So this is what Aadhaar case is all about. So what happens in Aadhaar case? A government of India have launched Aadhaar cards. Okay. And then there are different entities collecting those data. Then there is a breach happening inside these independent entities, and then the government says we are not responsible. So for more information you can read the Aadhaar judgment. Okay. Moving on. The act applies to. What is the application of the act? What is the ambit of the act? The application of the act relates to section 3A and 3B. Processing of personal data within the territory of India. So we are processing only those data which is being processed in the territory of India. Like the data servers are in the Indian territory. Understood? Then we have where data collected is in digital form or in physical form. If you are filling up offline forms or you're filling Google Forms, your data is being collected by any scenario, either offline or either online. In both these scenarios, your data is being covered by Digital Personal Data Protection Act of 2023. Data can be in any format, offline or online. This is the ambit. Then we have processing of personal data outside the territory of India, if such processing is being done to offer goods or services to data principal within the territory of India. We are not restricting our scope to the Indian territory. We're expanding it to foreign servers as well, where data is being stored. Okay. So wherever an individual's data goes, we are expanding our application on it. Number one, if individual data stays inside the territory of India, we are applicable, the act is applicable to the data servers which is based in India. If the data servers are outside India, data processors are outside India, independent bodies, still there is an application of the act. We are not restricting ourselves. Okay. Moving on, the act does not apply to. Okay. Okay. It does not apply to the publicly available data. Okay. Data which is not personal. If something is given on a government website, it is not protected by the act. Okay. If something is given in the public domain for the general public, it is not covered. Data used for statistics. If you are using the data for research or any data used for research or statistics, provided you do not use to make a decision about data principle. If you are using for research and statistics purpose, then there is no application of the act. So basically, processing of the personal data by an individual only for personal or domestic use. You should use the data only for personal or domestic use. Where the personal data is publicized by data principal himself, that is child or person with disability, or any other person who is under the obligation under law to be made such personal data is available. Obligation by law. In any scenario, this act is not applicable to you. Okay. Further, what are the requirements for processing personal data? It's pretty simple. The user should, for example, provide your users a notice specifying the purpose. For example, recently have WhatsApp in the year 2023, December, I believe, as far as I know, WhatsApp have a new privacy policy. In the year 2024, April, I believe, WhatsApp have another set of privacy policy towards end-to-end encryption and other sanitary policies. So your official policy should be in English as well as 22 official constitutional languages. Okay. This is the requirement for processing your personal data. So basically Instagram, Snapchat, Bharat Pay, Phone Pay, Facebook or Meta even. Okay. Anybody would be processing your data if they have made you aware or have given you a notice, like notice on the privacy issues, notice on the privacy policy, notice of terms of use in your English as well as 22 official languages. Moving on, to enable consent through clear and affirmative action, that we are taking your consent. If you are not consenting to this, then we are not processing your data. This is the clarity that should be given by the data processors. Okay. Then verifiable consent from parent or guardian. If you are under 18 or if you are a minor under the Indian Majority Act. Indian Majority Act does specify that you are a minor or not. For example, in case of female, the age is 18 years. In case of male, age is 21 years. There are certain amendments and there are certain specifics in which, for example, in contract, in terms of marriage, there are different age criteria given in different acts. Okay. Then consent is not required, particularly if data is given to you voluntarily for specified purpose. Okay. Certain legitimate uses. Why do we use a data? What are the legitimate uses that you can use? Just a sec. Okay. So there are the certain legitimate uses provided in the DPDP Act for which you can use the data. Okay. Voluntary provisions of the data. For state to provide any benefit, subsidy to a data principal. Now a data principal should not be restricted to the child and a public person with disability. It relates to every person. Okay. If the users voluntarily provide their personal data to data fiduciary who is processing their data for a specified purpose and has not indicated to data fiduciary that they do not consent to the use of their personal data. Okay. So you have voluntary consent to it. Then for state to provide any benefit, subsidy to data principal. State means, what does state means? State means government. Okay, current government. For the state or its agencies to perform. State have certain agencies, nodal agencies, different bodies, and if they want to give you certain subsidies, pensions, or they want to give you certain benefit, for example, Ladli Behna Yojana, Ladla Bhai Yojana, or you have different schemes, pension schemes, Pradhan Mantri Awas Yojana, and you want to get the subsidy, Pradhan Mantri LPG Yojana, or you have a certain, it does not relate to only central government, it also relates to the state government. If the state government want to give you certain subsidies, it would process your data. Okay, it would come under the legitimate purpose. So to provide any subsidy, service, benefit, certificate, license, permit to the data principal, where data principal has previously consented or such personal data is already available to the government in digital or non-digital format. So your data is already given with the government, provided with the government, that is Aadhaar data, PAN card data. That is the reason government wanted to link your Aadhaar and PAN so they can provide you the subsidies. Okay, moving on. For fulfilling obligation under the law, if you have certain obligation, then your data would be processed. Example, if I am driving my bullet to 110 speed and the permission limit is 80, there would be a penalty which would be imposed by parivahan.gov.in. I would get a notice and I have an obligation to fulfill, that is fine for 500 rupees for overspeeding. So thus my data would be processed in this manner. You cannot say how could have you taken my data with respect to transport of my vehicle, with respect to my phone number and other details, RTO details and extra. Data is already given with the data processor, and this comes under the legitimate purpose if you have a certain obligation to fulfill under law. For compliance of court orders, they will give you their warrant or summon on your WhatsApp. During the medical emergencies, during the spread of epidemic, during the disasters, for employment purpose, for safeguarding the employer from loss or liability. So these are the obligations that you need to fulfill. For fulfilling these obligations, your data is being processed for the legitimate purpose. Okay, understood. Then moving on. Data Protection Board of India. What does Data Protection Board of India entails? What does it do? What is the importance of Data Protection Board? Data Protection Board under the DPDP Act is being established by the central government. And Data Protection Board take up all matters, all disputes or grievances related to data, obviously. Why we have created this? Because we do not want our civil code to be burdened. Because civil codes are already burdened by other matters. We have created a separate authority. So this have certain rules and regulations which are being complied, which should be complied by you. So Central Data Protection Board, established by the central government. Okay. Civil courts are barred from entering suits or proceedings for any manner with respect to which board is empowered. If the board says these are the matters, this is the list of matters, civil court should not interfere. If there is another list of matters which Central Data Protection Board does not cover, then civil court can interfere. So if matters are silent, then your Data Protection Board would not be able to exercise their jurisdiction on it. Who would exercise the jurisdiction? The civil courts. Okay. So because data leakage is more of a civil as well as a criminal matter. Okay. We are not overburdening our civil courts with respect to it. We have created a separate authority, thus to reduce the burden of the court, so that there is a speedy dispute redressal mechanism. Okay. Moving on, the DPDP Act contemplates this. Under the DPDP Act, the Data Protection Board has the following powers. We would be dealing with the powers. So basically, to direct any urgent remedial or mitigation measures on receipt of intimation regarding a personal data breach. If there is a data breach happening incident, okay, what Data Protection Board, Central Data Protection Board would do? They would take certain measures. For example, there's a viral video which is getting viral on Reddit. This information is given, this data breach incident information is being given by the data processor under the law to the Data Protection Board. What Data Protection would do? They would curtail this data breach and would take certain remedial measures. They would involve their agencies, involve central government agencies, state government agencies to reduce or mitigate the effects of this data breach incident. Okay, to inquire into such breach, what was the reason of this data breach? We would hold an inquiry on it. Why would we inquire? Because such incident should not happen in the near future. Impose penalties for non-compliance. If the date, for example, data processor have a certain responsibility, data processor have not fulfilled that responsibility, thus there is a data breach. So data processor obviously have certain set of liabilities. In fact, data fiduciary have certain set of liabilities, and which is being imposed by in form of penalties for non-compliances by the Data Protection Board. Understood? Moving on. Inspect any document, summon and enforce attendance of any person. And even if you have a case, you go to Data Protection Board or Central Data Protection Board. Okay, they have given you a remedy and you are not satisfied with the remedy. You think the remedy is insufficient in the present matter, then an appeal can be filed against the order of Data Protection Board before the appellate tribunal within 60 days. So 60 days is the limitation period within which you should redress your dispute. So we have a Data Protection Board. The appellate tribunal is Telecom Dispute Settlement and Appellate Tribunal with certain rules. And still, if you are not satisfied with the remedy, you can go to the Supreme Court of India, the ultimate apex body. Moving on, what are the benefits and advantages of this DPDP Act? So this Personal Data Protection Bill or this Personal Data Protection Act have certain set of benefits and advantages. And what are they? The personal data may be processed only for a lawful purpose. Your data would not be processed for any unlawful purpose after obtaining consent. So the first point is purpose, which is lawful in nature. Then we have consent role involved. Okay. Individual below 80 years of age, consent will be provided by the parent or legal guardian. Let's see what implementation says, but still looks good on paper. Schedule 2, the bill specifies penalties for offences: 200 crore for non-fulfillment of the obligation, 250 crores for failure to take security measures, and thus it eases the cross-border data flows except the blacklisted countries. It will apply to the data collected in India as well as data processing outside the India. So this was all in all about the Data Protection Act. I hope if there are any doubts, you can clarify them in the comment section. And for more such information, you can subscribe to the channel. And if you like the video, please like it. and if you have certain suggestions, recommendations, then you can comment on as well.